A very good evening and a warm welcome to Afro Prime Time with myself, Ananda Khomo. Let's take a look now at your latest headlines. The Gupta family successfully challenges a seizure of assets worth 250 million rand in an important test case for the National Prosecuting Authority. Finance Minister Nhlanhla Nene elected chairman of the BRICS New Development Bank. Parents of grade 1 and grade 8 pupils in Gauteng have until midnight to apply online to secure space for their children or risk losing placement come next year. And police are probing yet another cash heist in Limpopo today, where suspects fled with an undisclosed amount of money. A top story this hour, assets of Oak Bay Investments are to be unfrozen. This follows a successful bid by the Gupta family to challenge the NPA asset seizures. The High Court in Bloemfontein found that there were no reasonable grounds to hold the assets. The National Prosecuting Authority had seized about 250 million rand worth of Gupta family assets. Now, the NPA alleged that funds meant for the Estina Dairy Farm project were laundered and deposited into Bank of Baroda accounts linked to the Gupta family. However, Oak Bay argued that the state's case reflects a lack of understanding of the banking system.
The NDPP might have had good reason to believe that the present application in terms of Section 26 would be determined on an entirely different basis than the Section 38 proceedings before Jordan J, and that those issues were therefore irrelevant to the present proceedings. As we have seen, such beliefs have been proved wrong. I therefore hold the view that the costs order should not be on a punitive scale. The following order is therefore made. The provisional restraint order in respect of the first to the fifth applicants is discharged with costs, which costs include the costs of two counsel. Mrs. Ronika Raghavan is the fourth applicant. She featured in the restraint order because of her alleged involvement with Oak Bay, Aerohaven, and the sixth and seventh applicants, namely West Dawn Investments Pty Limited and Annex Distribution respectively. It is alleged that she only became a co-director of Oak Bay since 14 September 2016. She was also a co-director of Annex, West Dawn and Aerohaven. Her directorship of at least Oak Bay commenced well after the dates of the relevant payments that went the way of Oak Bay.
Now, joining us in studio to further unpack this ruling is political analyst Professor Sipho Siepi. We're also joined over the phone by Paul Ngobeni, who is a legal expert, as well as Mr. Rudy Kraus, who's the attorney representing the accused, is also joining us via the phone. Mr. Rudy Kraus, let me start with you. A very warm welcome to the show. Let me start with you, sir. Your reaction to the ruling?
Evening, Amanda. I think that the ruling is unassailable. The judge correctly applied the law to the facts, and we are of the view that his judgment is correct and unassailable.
And now, what does this verdict actually mean for the Gupta family members and the others that have been accused, sir?
Well, most tellingly, the judge found that there is no reasonable belief established that a confiscation order would follow. The confiscation order is obviously dependent upon a conviction. So by necessary implication, the judge found that on the evidence presented to him, there is no reasonable belief that any of the accused charged in the criminal matter presently pending in the Bloemfontein Regional Court will be convicted.
Now, so one last question before I let you go. Your clients the Guptas have in the past said that they are the victims of a witch hunt. Now, will there be any legal action that the family will be taking, having put forward that statement?
Well, it's too early to say. The criminal case is still pending in Bloemfontein, and any action that they might want to take would be dependent upon the outcome of that matter.
All right. Thank you so much, sir. Thank you so much for joining us for this conversation. We move now to our political analyst, Professor Sipho Siepi, as well as Mr. Paul Ngobeni, who's our legal expert on this issue. Gentlemen, a very warm welcome. Let me start by your reaction to this judgment.
Well, it was interesting, but we should also say we are happy that you have the rule of law in this country, that when you are dissatisfied with the excess of power, especially those by the state, you can appeal to a different forum for adjudication. And here we see the Gupta family, which has been in the media, maligned and being accused of all sorts of things. They've decided to say, instead of fighting the media war, what we'll do, we'll go to the court. And what we also found interesting about the judge is that the laws that were being used, the prevention of organized crime, when you read it, it is one of the most permissive act. You have to struggle to prove your innocence. Actually, you could actually be found guilty simply on the basis of a lot of allegations, because the act, which is supposed to prevent organized crime, does say that sometimes it may be sufficient for you to be charged. And then there's a second one, that there must be a possibility of conviction for the exercise of the asset forfeiture unit, where they could actually say these assets might be confiscated later, so they need to be protected. So this is how the NPA had approached the court. But what was interesting about the court is also its damning statement against the NPA, because what was also very clear is that there was an affidavit that was missing, that the NPA had in its possession, but did not make it available to the courts. And the court found that to be an act of dishonesty. But there's something very important there, is that the court was saying, I do not take kindly to the NPA or an agency with state power to be approaching the court with dirty hands. And in that it came up with a very strong admonition, which actually is proper, because those who exercise state power, when they approach the court, must be seen to be clean. But here you have the NPA that was not clean. But the argument about whether this suggests innocence, it will be a bit taking it too far. But what it does, it says you still have judges in this country who are not easily swayed by the media onslaught. Actually, if you're to listen to the radio stations, the ones that have been in the forefront of maligning the Gupta family, some of those journalists, you can actually say they need to go through trauma counseling, because they can't come to terms with what has happened.
Yeah. Mr. Paul Ngobeni, would you like to add on to that, please? Your reaction, and also just anything else you'd like to add on to what this means?
Just agreeing with what Professor and the attorney just said earlier, I think this was a major blow for the prosecution, but we shouldn't stop there. This should spark a debate about the abuse of the asset forfeiture laws in this country, because here, if you look at it, the NPA took the position that because of the fact that the Gupta family was maligned, that there's so much prejudice sparked against the Gupta family in the court of public opinion, they thought that even in a court of law, similar prejudice would prevail against the Guptas. And when they got to court, they took an extremely lazy approach, which was that they didn't have to prove a strong case against the Guptas. They failed to meet even the minimum prosecution-friendly standard of proof that is applicable in this kind of asset forfeiture or preservation order cases. So, for instance, the NPA took the position that because they were not seeking a confiscation order, they were not at that stage yet, they were simply at the stage of the preservation, seeking a preservation order, that they didn't have to prove reasonable grounds to believe that a crime has been committed. They only needed to prove a suspicion so that the properties could be preserved. Now, if a mere suspicion could be enough to persuade a judge to order that your assets be seized and be placed under a curator, basically to deprive you of the use of your assets, while a case is yet to be filed, or even if the case is filed, while a case is yet to be brought to trial. I mean, you can imagine the draconian effect of that. And this is exactly what the NPA wanted to do. So that's why I'm saying we need to look beyond just the politics of the Gupta case. We need to start asking ourselves, in a constitutional democracy that we claim to be, can we allow that kind of abusive, standardless basis on which the NPA can seize 250 million rands of someone's money, based on the kinds of allegations that it's not even able to prove. And lastly, I just want to point out that the standard for the preservation order is much more relaxed, it's much lower than the standard that the NPA will have to prove in its criminal case against the Guptas. So when you ask whether there are any legal steps being contemplated, if I was the Guptas, I will be looking very closely at what the NPA is now going to do, given that it could not even meet the lower standard, the prosecution-friendly lower standard. How can they hope now that they will be able to get a conviction in a criminal case beyond reasonable doubt against the Guptas?
Okay. We'll come back to this when we chat about... Did you have something to add, sir?
Yeah, actually, the point that Paul was also raising is a simple one. If you look at how permissive the act is, you're talking about an act that talks about reasonable grounds for conviction. And what the judge decided to do is also to introduce the notion of reasonable doubt. And I think reasonable grounds, it's a far lower standards, because it says it's almost about suspicion. If you suspect that you could go there. But when you talk about the reasonable doubt, it talks about where you are able to show that a certain activity can be explained by a number of factors, that it is not only one. And when the court makes a judgment, it must be, the evidence must prove to one point only. There must be a convergence. The force of logic and the facts must say there can only be one conclusion here. And the very basis of pointing one-to-one direct link was not there in the case of the prosecution. So you find the prosecution that had become lazy. And actually, as Paul was indicating, is that he's probably saying these are the people who have come to rely on the power of the media. But as I say, for me, it is too early to say the Guptas must celebrate. Yes, the standards may be higher, but what we do have in this country, we also have judges who we know in their behavior that every time they come up with a judgment, all they can think of are the media headlines. And those are the judges that Mkhwe had actually said, judges who are driven by any other consideration other than justice are actually corrupt judges. Mlambo himself once talked about that, and the notion of the corrupt judiciary is something that is being suppressed as if it doesn't exist. But what we should also know is that the notion that one can always get justice from the legal system is a very misguided one. This is why you can have judges who can look at the same documents, interrogate the same witnesses, and come up to contradictory conclusions, because most of them are driven by other things other than justice. But what we have done in this country, we have tended to treat the judges as demigods, and they are not demigods. They are very fallible. But what the judge here tried to do painstakingly was to say, you have not done this. And I don't think the NPA did want to argue about its failures.
Yeah, and now what you both gentlemen just said leads me to my next question. Well, leads me to two, but I'll touch on the other one. The one I want to go to is the fact that the Gupta family has been at the center of state capture, and that all their wealth has been through the proceeds of crime. Now, that picture, has it been tainted by this ruling? And if so, how?
No, I don't think it has been tainted by this ruling. What the ruling has actually done, it has cast doubt on those who had made claims against the Gupta family, that you need more than howling, you need more than repeating the same allegations, you need more than simply playing to the gallery. You need to have evidence that shows a direct link between what you call an act and the benefits and those who benefit. So that when you talk about firstly, you must establish a crime. Then you must also establish that there are proceeds of crime and then indicate who are the beneficiaries of that. So that should be a line that is very straight. It cannot be a line that it becomes anybody's guess, whichever it falls. If they mention your name, then you are guilty. If they don't mention your name, you are innocent. So this is, as I said, it's a politics and justice through tatamachance. That let's throw the book and let's hope that things will work out.
Mr. Ngobeni, do you have anything to add to that?
Yes, I think even just looking at the fact that the state tried to come up with the most absurd theory in terms of having money that was in a pool account, and then claiming that even though they knew that other entities, Gupta-owned entities, had accounts with the same bank, but trying to argue that all of the money that came out of that pool account were proceeds of crime. And when asked to come up with proof of that, they couldn't. And that tells you that even this whole far-flung conspiracy theory about state capture is going to suffer from the same infirmities, which is when asked to prove specific offenses, people resort to generalities and character assassination. And that's what has been happening to the Guptas all along. I'm not saying that the state does not have other evidence of any other criminal activities that they may be involved in. But when the state resorts to generalities, instead of dealing with facts and evidence admissible in a court of law, then we know we are all in trouble.
That's what I was going to actually lead it to. If now the Hawks and the NPA seem to be making shoddy investigations, if I can put it that way, how much faith should we have in them going into the State Capture Commission that's starting in August?
Well, the excitement that we see politically has actually put pressure on the state agencies. We have this notion that there's a new dawn, and that new dawn must present evidence. So there is a pressure on people to start behaving, to deliver something, almost to create a notion that we are in a new dispensation, as if the new players have not been the old players. Actually, if you look at the National Executive Committee of the ANC, and most of the people in government, these are the same people who have been there in the last 5 years, the last 10 years. And there's a pretense that just because they now occupy different positions, suddenly we'd expect a different behavior. So what you have here is that we've been subjected to a PR exercise, and it has put pressure where the state agencies that have power, the state apparatus have become even reckless. But also I think part of it is that you have people who want to be accepted in a media space. And if you're not accepted in a media space, you feel like you have not done your work. So this judge, if you listen to the radio stations, there is such a chorus of condemnation, because the very people who've been champions, the drum majors, are the very same people who are now disappointed. And so I do think that we need to take a step back and start asking for rigor rather than come up with generalities and innuendos, and where you can then tarnish people's images. But that's how it has always been. And I don't think the judges in this country have served us that well, because even some of them have actually fallen into sense of popularity.
Mr. Ngobeni, your contribution?
Well, all I can say is that in addition to what Prof said, I agree with him entirely, but I think we as a society need to start moving beyond the issue of just focusing on the the bigotry that we may have against the Guptas. Start looking at how our laws are being applied in the courts. This poker statute that was used against the Guptas to try to seize their assets and so forth is the most draconian piece of legislation. It was designed to deal with organized crime, not to deal with ordinary run-of-the-mill corruption cases like what they claim the Estina dairy project was. I mean, there was no need to have come up with this far-flung conspiracy theory that suggests that all of the money that the Guptas and Gupta-linked companies had in Baroda, Bank of Baroda, were all proceeds of crime. And that's absurd. It's a theory that will simply not fly. And it's very important that we exercise restraint in terms of how we deal with the constitutional rights of even the most disliked criminal suspects. We still need to recognize that these people are presumed innocent until proven guilty in a court of law. And until we meet that standard in a court of law, in a fair trial, we should refrain from labeling people as criminals. And if you look at the media onslaught on the Guptas, particularly on the so-called Estina dairy project, which even members of parliament were opportunistically jumping into. That is something we need to really caution ourselves about. Ask ourselves, are we sincere? Are we not hypocrites when we claim we live in a constitutional democracy, and yet we show no respect for people's rights under the Constitution, including the most basic right, which is the right to be presumed innocent until proven guilty?
Now, so coming off that, we also saw that these raids happened at a time where the political guard of the country was changing, where the government was taking a strong stance against corruption. Is there any coincidence here? Well,
I think, first of all, we need to deal with crime, and wherever it raises its ugly head. And to have an energized state agency, there's nothing wrong with it. But we cannot have the agencies working because they want to please the political master. Because then when they do that, then they are also corrupt. What we need is agencies that act without fear and prejudice. And there's a sense that one is getting that there is a way in which that itself is being undermined. But also what the advocate was also saying, which is very important, is a notion of presumption of innocence. This is the basic tenet of our democracy. And yet you often hear even people who are highly placed that if you are innocent, go to court to prove your innocence. I mean, as if, and you cannot even understand the contradiction there, that in this country, the presumption of innocence is sacrosanct. Otherwise, what you're going to do is that people are going to be found guilty, and then they have to be dragged. And to try to prove your innocence is harder than where the state, which has all the machinery of investigation, should actually be proving that you're guilty. So what this case must do is to actually, as the advocate Paul Ngobeni says, that we must suspend our bigotry and apply ourselves to say what is the letter and spirit of the law. Because if that can be done to any other person, actually the law is best tested when it is applied to the people we dislike intensely. That if you can be fair to those people, then you know you have a democracy. But if you are willing to have the people's rights rough short because you don't like them, then you don't have democracy. Actually, what we should also guard against is the judicial tyranny that is fast creeping in. Something that Mogoeng himself had said, that you see judges who, because of excitement, tend to overreach, get you into the space that is not theirs.
Mr. Ngobeni, you gentlemen seem to be agreeing a lot. Mr. Ngobeni, are you of the same view?
I'm of the same view. I will only add that if I was Mr. Abrams, this will be a wake-up call to suggest to him that the change of the change of the guards in the political sphere should not be allowed to determine how he makes charging decisions. And this case involving the Guptas, he needs to look at it very, very carefully, because it may very well be one of those cases that prove to be his undoing. That actually shows that the NPA is not independent, that it's susceptible to political influence or that it listens to some political masters before it charges criminal suspects.
All right, gentlemen, that's where we have to wrap it for today. Thank you so much. That was our legal expert, Mr. Paul Ngobedi, as well as in studio our political analyst, Professor Sipho Siepe, talking to us about the unfreezing of Gupta assets worth 250 million today by the Bloemfontein High Court. Now, Afro Worldview would like to remind viewers that the NPA was invited to participate in this discussion. They replied they did not wish to engage in a television debate over the court's ruling. Spokesperson Luvuyo Mfaku did, however, give us a bite that we have used several times already. Here it is. We'll have more news for you after this short break. A quick look at your weather. Stay with us.